and welcome to a Newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. What have you been doing lately since I last spoke to you?
Not very much.
You've been downloading a podcast?
Downloading podcasts, getting ready for the next one. So we are here on your birthday eve, as you keep reminding me, to talk about a case on the 12th of February.
Don't forget it's not any old birthday.
It's the big 40.
Yeah.
Yeah. So we're here to talk about a case from the 12th of February, which was all around boundary disputes in commercial property. And it's a High Court case called Handy Cross Development Co. Limited and Vanni Properties Ltd. So, shall we get into it? Do you want to tell us the background to this one?
Devco, I think it's down in the title. Yeah, I mean, we've had a lot of kind of boundary issues cases this last year or so, including those ones on boundary agreements, that White and Jack from last summer that we did a podcast on. But this is a commercial property boundary issue dispute one, and it's very useful, in particular for people like local authorities as well. I'll tell you the background facts, shall I? We'll go through that. It all took place on the edge of High Wycombe, just off the M40. Do you know it?
High Wycombe? Yes, I do.
Yeah, the M40. I know it. I used to do quite a lot of courses in some hotel around that kind of area, actually. But the council owned the land. It was a brownfield sort of with no distinguishing features on it site, but they were selling it off for development, and there were three specific, sort of people going to build on these three different parts of this land. One part was going to have a Waitrose on it, but they weren't involved in the dispute, so we won't deal with them too much. But the Handy Cross Devco were going to build a Hilton hotel, and did build a Hilton hotel eventually on it. Hilton being primarily a franchise. It was called the Hampton by Hilton. And Vanni Properties had a neighbouring premises, which was going to be its offices and self-storage units. And it seems that, the Handy Cross were the first to exchange in November 2018. The council being selling, Wycombe District Council being the sellers. They exchanged contracts and then completed in December 2018. And they had planning permission to build this hotel, but they intended to make an application to amend the planning permission with the council. The Vanni bought the neighbouring property in April, I think it was, of 2019, and sometime in 2019 anyway. And in the meantime, the planning application, the amendments to the planning application had been made with the council. When it was first laid off, when the Hilton first acquired this land in December 2019, the boundaries were such a large scale that they didn't really, with accuracy, state what the boundary was, and in the transfer itself. But there was a separate drainage plan, laying out where the drains were and so on. But that was stated to be, unsuitable for scaling, so that shouldn't be relied on either. And then when they made the application to amend the planning permission, they provided obviously plans to the council's planning authority, which quite separately. They built the hotel. It was completed about 2.5 years afterwards, after they'd completed, and also an access road. And then the dispute arose that Vanni, if that's the way you pronounce it, seemed to have what they claimed did Handy Cross, that Vanni had trespassed on their access way. It should have been their land. Originally in the county court, they were claiming a large piece of land. Vanni had built this sort of wooden hoardings, which Handy Cross were claiming was the encroachment. they got in trouble with the county court for being a bit too greedy as to what they were claiming with their land. So they reined back when it got to the High Court. We're only claiming a 3-foot wide stretch of land, which was in dispute on this access point and these hoardings. And that's basically what the case was about. If you got an accurate, a plan which is not sufficiently accurate, how do you determine there weren't any boundary features that helped? But how do you determine where the boundary should be? And that was what it was all about, Lizzie.
So what happened next? What did the court say?
They sort of more or less confirmed the county court. Basically, what happens if the plans are not sufficiently accurate to determine the boundaries? You've always got a general boundaries rule in the land registry anyway, unless you've successfully applied to determine the boundaries of the land registration rules. But they tried to argue, did Handy Cross, that you should be able to rely on the planning application and the plans, in the planning application, which would sort of confirm where the boundary was, because the local authority had approved these things and the local authority was the seller. The High Court and the County Court refused to accept that. It's a case called Allen Lane, which is 2007, the Court of Appeal case, which basically said you can have extrinsic evidence to decide what the boundary should be, but only if the boundary is unclear. Then you could introduce extrinsic evidence, but the evidence has to be probative. It's got basically a way of actually proving the boundary. And that wasn't the case in Allen Lane. And you could sort of look at things that have happened post-dating the actual laying down of the boundary and conduct. So that's what they're basically arguing. And we can use this, plans in the planning application. The High Court basically said that if you're looking at post-dating conduct, then it's got to be bilateral between the two parties. And this wasn't bilateral. It was just a unilateral planning application. And also they said that it's a well-established principle. This is why it's important for local authorities and possibly other bodies as well, who have sort of diverse functions. The fact that the planning authority is quite separate from the local authority estates and so on. And the fact that the planning authority had accepted these plans didn't mean to say that it was binding on the estates department at Wycombe District Council. So you could look at the drainage plans to determine the boundaries, and that was basically it. Handy Cross basically lost.
So why is this one important?
Well, it's important, I suppose, because of what I just mentioned. If you're somebody like a local authority, but other bodies with functions like that, it's an important sort of issue. You distinguish the various roles you have. There'd been a case that they quoted, Maximus Networks, which was about sort of phone kiosks, and the Secretary of State, which had said that, I think in 2018, a similar thing. And it's, your planning role is quite separate than your sort of estate's role and sort of management and selling of properties. And also, sort of bringing forward Allen Lane, and that any post-dating conduct has to be bilateral, and also, purposely it determines the fact. You can only look at intrinsic evidence if there's also a sort of question mark, an issue as to whether how accurate the plans are. How the plans from 2019 weren't sufficiently accurate, and there's another matter. And that's it, Lizzie.
Thank you very much, Richard.
My pleasure.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.